Appearances, please. Yes. 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 Very well. Well, I'm seeing a shadow, but there's nobody there. Where is Inka? So what's her name? Ifoma. Ifoma.
And I'll just place the call to her on WhatsApp.
Okay. Thank you.
She's lucky.
Very well.
She
Okay.
will be with us. I'm very grateful, madam.
Yes.
I think she has now joined us.
Ifoma, are you here now?
Yes, ma'am.
Okay.
Good afternoon, ma'am.
Yes,
ma'am.
I can see you. I can see her.
Okay. Thank you, ma'am. So sorry, ma'am.
Okay. So, Council, I guess you can start. Wait for the comment. Okay. She's here now.
But I think we need to be reminded that.
Okay, because she had she was sworn. Let's see. Ifoma,
Yes, ma'am.
you recall that you have given evidence
Yes, ma'am.
and you were cross-examined in part.
Yes, my lord.
And you are still bound by the oath you took before you started your evidence.
Yes, my lord.
Okay.
Thank you.
Is still bound by it.
And last agenda, we stop at the point where we sought to tender contract of employment.
Yes.
Dated 20th of January 2016.
Yes.
And the court did direct that the counsel to the claimant scan and show the document to the claimant.
Yes.
Provide identification.
Yes. Did you do that?
Yes,
Okay.
my lord. Just before that, I actually carried out the directive of the court, but also to remind the court that I actually raised an objection to the admissibility of the document based on the fact that it was never pleaded. It was the court that now said it should. In any case, just make it available to the claimant to see and identify. But our objection that it wasn't pleaded, my lord, still stands.
Okay, but to recall that we usually admit all these documents, and your objection will come at the final written address.
As the court places.
Okay.
Just to be on record, my lord.
Okay.
All right. My lord, we have shown Informa the document, and she will then react, my lord.
Okay.
And also responded to that objection.
Yes.
Cited previous policies to the extent that the document is relevant. Yeah. So, Madam Ifeoma,
Yes, please.
please take a look at this document. Can you see can you see me?
No, I can't see you. I can only see my counsel.
Okay. Can you even see the court?
Yes, ma'am. I can see you as well.
Okay.
I just can't see the defendant's
You can
counsel.
see.
So can you then give it to her counsel to?
Okay.
Ifeoma,
Yes, please.
let me show you the first page. Can you see? Check through my.
I can see it. Yes, please.
You can see it. I can confirm to you that it is the same with the copy that I shared with you.
Okay.
Okay, let me just open through all the pages.
All right. Okay.
Can you see the last page?
Yes, I can.
Okay. All right. I will show the Informa the document.
We seek to tender the contract of employment dated 20th of January 2016. My lord.
Okay. Now, counsel, why don't we? Okay, we've admitted some documents. I wanted it's better for us to admit them together than doing all this individual identification and application to tender and all this. So is there your objection?
It's actually cross-examination. They are tendering the document during cross-examination, so it's not their time to actually, but since it's allowed by the our objection is what we would defer to the final written address as entered by the court.
Very well. Okay. Finance Council has an objection. Just a moment. Let me see the document. What was the last exhibit we had? Registrar. What was our last exhibit?
Yeah, 11, my lord.
C11, yes. So the Learned Council to the defense seeks to tender the contract of employment dated the 20th day of January 2016. The Claimants Council informs the court that he has an objection on this document, but defends them to his final written address, as is the practice here. Court, a document titled Employment Contract dated 20th day of January 2016 between Next Nigeria Limited and Ifeoma Esekaka is hereby admitted in evidence and marked exhibit C12.
As a corporate.
Yes, yes. Exhibit C12. Yes.
The photo of the C12. Madam Ishoma,
Yes, please.
you will agree with me that you read this document before you appended your signature.
Yes.
Can you speak loudly, please? So,
Yes, can you hear me? Can you hear me?
we can hear you.
Yeah, I said yes, yes, I can.
You read the document before you appended your signature.
Yes, my lord.
Yes.
And that you will also agree with me that that document contains what you call probation period.
Yes,
Paragraph 4.
that's right.
And
The what period?
probation period.
Okay. Yes.
And that the probation period was for a period of 6 months.
What is the
That's
answer?
right. Yeah, that's right.
Okay. Okay.
And you resigned your employment on 15th of June 2016.
Yes, I did.
Yes.
And that during this period, you have received queries. Is that true? From defendant?
I think we dealt with this at the last. I don't know. Is it the same person?
Is just answer the question.
Yes, we did, and I did explain that that was the practice of the defendants. Yes, they sent queries to everybody following the new policies they put in place, which was hindering our performance for everyone. So I did answer that at the last sitting.
So I will take the explanation as yes, you received queries. Is that correct?
Yes.
As accomplices. And that it was within that probation period that you proceeded on maternity leave. Is that correct?
I'm sorry, I was not on probation period. I started working with the company in November of 2014. The company then decided to make some changes in 2015. Maybe you need to, I think you may need to rephrase the question.
To maternity leave in April of 2016.
Yes, please. On the 25th of April, 2016. Mm-hmm.
Yes.
In your statement of oath before the court, which I'm adopted. Are you with me?
I can hear you, please.
Okay, thank you. In paragraph 17 of that statement, 17 to the precise, you said women were singled out.
Yes, I did.
How many women?
3 women.
3 pregnant women.
No, brother, okay. You did not give details of these people. Yes or no?
So, sorry, my lord. Sorry to interject. Counsel has sought to explain a certain question that he asked, which was not clear to the witness. I will implore counsel to repeat that question again. It was around probation and the time where she went on. Yes, she
understood the question.
Can you please? I don't think she answered it.
Okay. No, I didn't. I was waiting for him to rephrase.
Yes.
I did repeat the question by asking that she proceeded on maternity leave in April. I said yes.
Yes.
No, that you didn't. You were talking about probation. That had nothing to do with the probation.
Yes, my lord. That portion of probation has not been answered.
My lord.
No, I think he abandoned it and said, let me rephrase. He went elsewhere. I guess he will come back to it.
I just want to be sure that, yes, I just want to be sure my lord had not recorded the earlier answer given by the witness.
Yes, because I'm just recording her verbatim.
Okay, my lord.
Yes.
Let's go back to that question again for clarity.
Yes.
You proceeded on maternity leave on in April 2016. Is that correct?
Yes, that is correct.
That's what is on record.
As a couple. So I now went further to say that in paragraph 17.
You said A.
17.
A, okay. Which he has adopted, you said. Yes.
You did say that 3 women were singled out.
And she added 3 pregnant women. Yes.
Now, my next question was now that you did not give particulars of these women in your statement on oath.
Yes, at the last sitting as well, this was asked, and I did say that was an omission. I mentioned their name. Ombobolaji Ogabi Samuel was one of them.
I am asking the witness.
I'm the one answering.
Hold on. we are before the court. And you should just respond to my question, not just everything that you want to explain and you explain in your statement. I'm asking very short questions so we can move ahead.
I just answered your question. I'm answering exactly what you asked me.
My question is, in your statement, you did not give details of these women, yes or no? In your statement.
In my statement, I did not mention their names as I confirmed at the last sitting, and I'm just going to mention their name now: Omobolaji Ogabi Samuel and Toyin. I'm just, what's Toyin's surname? I'll need to confirm her surname, but Omobolaji Ogabi Samuel was the one that also attested this document you've just pleaded.
We can proceed now.
Okay. Omobolaji Ogabi Samuel.
Samuel, yes, my lord.
Okay.
In paragraph 17F.
Yes. Yes, come again.
In paragraph 17F.
Yes.
Are you there?
Yes, I can hear you. I'm listening to you.
You said that you were devastated.
Yeah, sure.
Did you seek for any assistance anywhere?
What do you mean by that? I'm sorry, I don't understand that question.
Do you have get to medical attention? Any medical attention?
I was devastated. I didn't have to get hospitalized. I didn't have to go to the hospital.
Madam, you don't need
no, I was not.
You don't need to reframe my
did
question
not
before you respond to it. Just respond.
No, I did not go. I did not go. I did not have any. I didn't have to go into the any hospital.
As a complicit. Thank you.
Very well. That's all right. Yes.
In paragraph 17G, you also stated that you were ridiculed and disrespected.
Yes, please.
He was what?
He was ridiculed and disrespected.
Can you finish the sentence, please?
That was your statement.
Yes, so can you finish the sentence so that I'll have it in context?
You said you were subjected, okay. Sir. And as consistently subjected me to ridicule and respect of dignity of my person.
Yes, I was subjected to ridicule and disrespected, yes.
You did not provide this court with the details of anybody in whom presence you were disrespected or ridiculed. Is that correct? Is that correct?
My lord, this evidence is before the court. The statement on oath has been admitted already.
Yes.
If you must ask other questions to challenge those, you should ask, not confirming what is already adopted and before the court.
Yes, that was what I just wanted to say, because
as a court pleases,
all these things that you are writing, she's repeating what is in her statement on oath. Yes.
I have a question after I read a portion of the statement. It was not just for her to confirm.
And all these questions have just been the same thing as you wrote. What I'm driving at is, if there is any part of her statement on oath that you disbelieve or that you want to attack, you can do that. Let us not go through the statement on oath for her to say, yes, I said this. Yes, I
as
said
a court pleases. I'm very grateful, my lord.
Yes.
Thank you, my lord.
Thank you.
You will recall, witness, Are you with me?
Yes, I can hear you.
That the defendant called on 3rd of September 16 to return the company's property.
Yes,
And did not heed to that call on the 23rd of September. Is that correct? Correct.
that's not true.
As a complicit.
That's not true.
Okay.
I returned the company's property promptly, as I was requested to do, which I put in my statement of oath.
Yes.
You will agree with that. That the letter of employment of 7th of November was not passed in paragraph 22 of the written.
I'm sorry, I didn't quite get what you just asked. Can you repeat that, please?
The letter of employment.
There seems to be an echo.
Yes, did you say that?
I'm about to leave the meeting on my laptop so I can.
Okay.
As
So did you say employment?
as complicit.
Okay. Okay.
The letter of employment of 7th of November 24th
Yes.
was not the letter you referred to in paragraph 22 of your statement. Am I correct?
The letter of employment was not the same letter I referred to in paragraph 22. The only letter of employment I referred to was the one I signed with the company. So I'm not sure what you're asking or what you're referring to.
Unless you can I clarify?
You
Please.
said,
Can I clarify, my lord?
the issue is whether this letter she referred to, she signed it or not. Because she said the one that she referred to is the one.
No, I'm not asking whether she signed.
Okay. No, it's not the one that she referred to in paragraph 22 of her statement on oath. Yes. And she said the only letter she referred to is the one she signed. What is echoing thing?
Yes, you have to leave.
Thank you.
If you object,
Yes.
Just confirm that she has a copy of the statement on oath with her.
Yes.
Clarify what paragraph counsel is actually.
Yes. Paragraph 22 to be precise.
Yes. Let's confirm that she has a copy of the statement on oath with her.
Okay.
Yes.
Do you have
yes, I do. I'm just having a look into it. Just
paragraph
give me a second.
22?
The statement on oath, not the statement of fact.
Yeah.
Statement on oath, the first one, right?
that should be the first one.
The first one,
The first one.
statement of oath, not the statement of fact.
Are you there?
Yes, ma'am. I'm just
Okay.
bringing
Okay.
it, having a look into it. Okay. There we go. Assessment of oath, paragraph 22, you said.
Are you there?
Yes, I'm here.
Have you checked
Okay,
your paragraph 22?
Yes, I'm on paragraph 22.
Okay.
Okay. So can you ask can I understand what the question is? Because I'm looking at paragraph 22 now.
In paragraph 22, you referred to a contract of employment. So I wanted to be sure if you were referring to the contract of employment of 7th of November or another one.
The letter of employment was what I referred to. Letter of offer of employment. That's what I referred to. And as at then, of course, I didn't have this contract of employment that you have just presented. So I couldn't very well be referring to that. What I was referring to was the letter of offer of employment, which was given to me when I joined the company.
Okay.
And I did specify that it's letter of offer of employment. I didn't say contract of employment.
As a couple places. You left the company as business manager. Am I correct?
Yes, please.
In paragraph 24, 25, 26, and 28 of your statement, you make copious reference to one Mr. Jeff Unadike. Am I correct?
I don't know what you mean by copious. I did make mention of Jeff Unadike, but I don't know what you mean by copious.
Okay. You made reference.
Thank you.
Repeated, yes, it was repeated references that you made to him.
Thank you.
Yes. You made reference to Jeff Unadike.
Yes, please, I did.
As a accomplices.
Yes.
Except for the mail of 25th of October 2016. There was nothing to prove your conversation with Jeff Unadike, except for that mail of 25th of October. Am I correct?
And I relied on the mail of 25th of October 2016. That's what I relied on.
Except for that mail, there is no other thing to confirm your conversation or discussion with him.
Mail of what date?
25th of October 2016, sir.
Okay.
That was what I tendered. The mail trail from 25th of October 2016. That is what I tendered.
Yes.
As accomplices.
Yes.
In paragraph 33.
Yes, please.
You referred to a document given to you by CIO law firm.
Yes, please.
Please, do you have a copy of that document? With you? Do you have a copy with you?
A copy of what document? What document in particular are you referring to?
I'm so sorry, man. I want to refer to it. I'm looking for where I labeled it. Exhibit. But it is
it before the court?
It's before the court. It was tendered by the witness. So sorry. Oh,
Are you referring to the fee notes?
As accomplices, yes.
Yeah, and I did present that. So that was part of what I tendered in as evidence.
What did you call it?
It was a fee notes from the law firms. Yes. CIO attorneys.
Okay. Very well.
A fee notes of 500,000 naira.
As accomplices.
Yes.
You will agree with me that that is not a receipt of payment. Am I correct?
What I tendered was a fee note.
As accomplices.
If you need a receipt, you can ask and I will give that.
As accomplices. As accomplices. I just wanted to confirm. My last question is on privacy.
I'm so happy that you're saying the
As a
last because
as a
you've
complicit.
really gone to town on this cross-examination.
As a complicit.
Yes.
So in the mail that you sent for your resignation, dated 15th of June 2016. Please, can you confirm how many people who are in the copy in that mail? If you can, fine. If not, it's fine.
I'll just pull up, just give me a second. I'll pull up the email because I keep on my records. 1 second.
No, even
and the people that were copied, I'm sure appeared on the.
It was a forwarded email that
and even though the last cross-examination, the last bit was in February.
Yes,
I still I think I can still remember when she said that maybe the letter was seen by many people.
As a copy.
That's evidence. I think she questioned him one way or the other on that.
yeah, because
She said, actually, she said, I did mention the name and dates of the people who traumatized me. My letter of resignation was probably sent to more than one person. That was in February, she said that. And it's still, I think she still, yes.
Okay.
So that probably answers that.
As a complicit.
Yes.
I noted it as an unanswered question in my record. That was why I had to come back to you.
Okay.
As a complicit, my lord. And you will agree with me that in the internal memo dated 9th of June 2016, that memo was an advice. Am I correct?
Dated when?
9th of June 2016.
what internal memo are you referring to? Is it the one asking me to resign? If you can just specify.
Yes, I was asked. Yes.
Okay, so the
it was an advice.
And I recall you asked me this question the last time, and I did respond saying that I didn't see it as an advice. I saw it as a threat because that was what it was. I was not given any other option. If you read through the memo, you would have seen that that was a clear instruction and that was a threat. So rather than refuse to resign and get terminated and have a dent on my career, I chose the honorable path. And I also stated in my statement of oath that I was very disheartened, and that the defendants could do that to me, seeing I was on maternity leave and all that, and I resigned. So it was not an advice, it was an instruction and a threat.
So everything you said now is your own interpretation of that document. Yes,
but
or no?
you just asked me what's
everything that you have said now is your own interpretation of the document.
That is the answer to your question. You asked me if it was an advice, and I told you no, I didn't see it as an advice. I saw it as an instruction, a directive, and a threat, which I complied to.
Madam, lastly.
I said finally.
Lastly,
yes,
this is the last.
As a complicit, my lord.
Yes, please.
A proposal was made to you for payment, which you refused. Am I correct?
A proposal was never made to me for payment. If you read through my oath, there was never a proposal. I still sent several emails after asking for payment. The company had my account details up to today, and they never made a payment.
As a complicit, that will be all for the witness.
Very well. Re-examination.
There's none. I will feel for witnesses like if your man all the time.
Yes.
That's done well. I don't need to re-examine.
Very well. Neil. So, Informer, we are done with you.
Thank you very much, my lord.
You did well.
I can log off. Thank you very much, ma'am.
Yes.
I can log out. Thank you, ma'am.
Yep.
Okay.
Guess what? Very well.
My Lord, sir.
Yes.
In the circumstance, would have loved to go straight into our defense, but we understand
Today.
the mood of the court.
Okay.
And we shall be praying for a date. Meanwhile, we would need to file an application to substitute our witness because the witness on record has left for greener pastures.
Okay, so the mood of the court has nothing at all. Nothing at all to do with what is going to happen now.
I just hope the witness has not been advised again.
No. Okay, then. Tell us how long you think that will take.
My
So
Lord, we
that
can
will
come
be-
next week, my Lord.
Really? You can get somebody before then. No, the court cannot even. Next week, the court has an official engagement. We're all going for something, everybody.
It's coming from motion actually. But you want to try on that?
We're going to try.
Okay, so we'll have served us.
Okay. 21. Certificates. Yes.
We come any day between the 11th and 15th of December.
I was thinking that the best time will be ending of January and early February. This is a baby case, but because both sides have been diligent, that we are going to conclude it in no time. But it has to be, let's say, 1st or 2nd of February, if it's a working day. Okay, let us see the end of January, how it is. How do you stand on the 30th, 31st? This is a case that is straightforward. I just want us to, yes. 30th. No, okay, you've come back. No, I said 30th. 30th, if, okay. Yes. So this matter is now adjourned to the 30th day of January 2024 for defense. Yes, counsel. So whatever you want to do, you do it if it's something that will take time. It has to, because that day your defense will start. Okay. Now, by the way, is your defendant, is your witness going to be in court? Are we coming by? Okay. Thank you. I see. Okay. I hope he will come on that day so that.
Well, aside that, if you need to, just amend, just also advise him before that.
Okay. Very well. So the kosher rights. Thank you.